नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
He told us that the president shall exercise executive power either directly by himself or through officers subordinate to him. Let me just open my copy of the Constitution for one moment. Yes. Executive power of the Union shall be exercised by the President or officers subordinate to him in accordance with this Constitution. And then I pointed out to you Article 77, which tells us the relationship between the President and the officers subordinate to him. Look at Article 77. It tells us all executive action shall be expressed to be taken in the name of the President. So while 77 clause 1 tells us that all executive action is taken in the name of the President, I want you to just for a moment look at what Article 300 says and see how 77 and 300 are related. 300 tells us that the government of India may be sued in the name of Union of India or the government of the state. So the executive action is taken in the name of the President. But when you want to sue the government for discharging the executive action, you will not sue in the name of the President, but you will sue in the name of Union of India. And you can see why this is so. One, under Article 361, in the name of the President and the Governor are given immunity. Number two, though the President exercises power directly under 53 either himself or by officers subordinate to him, and also 77(1) tells us that all executive action is taken in the name of the President, yet when it comes to judicial proceedings, it shall be done in the name of Union of India. So the President as a constitutional head is never dragged into litigation. In fact, when the Constituent Assembly was, and I had mentioned to you in the earlier class, 2 classes earlier on, about whether we should have a presidential or a parliamentary form of government. But presidential, what I mean is that the head of the government and the head of the state is the President, like in the United States. Or a parliamentary form where you could or could not have a constitutional head, okay, but here we have the President, but actual governmental power is exercised by the Prime Minister reporting to the Parliament. And Dr. Ambedkar tells us that the parliamentary form has a great advantage of having responsibility, even though it may lack a little bit in stability compared to a directly elected president. And there was a trade-off between greater stability in the presidential system and greater responsibility in the parliamentary system. Now, this idea of parliamentary accountability and parliamentary responsibility is something that comes to us from England. And if you look in England, for the longest period has been a monarchy. And different dynasties, of course, have ruled England. You have the Normans, you have the Stuarts, you have the Anglo-Saxons. There has been always different rulers in England. But in 1688, which is the date that I have put down, why I have put down 68 is that it's often known as the date of the Glorious Revolution. And why is this important for us in the study of Indian constitutional law? That 1688, James II, who was ruling in England, was a Catholic. And, you know, the Church of England, right from the time of Henry VIII, has been an Anglican church and a Protestant. I think as students of Indian constitutional law, it's important for us to recognize it's not that it's only in India that religion plays such an important role in constitutional development. It has played an enormously huge role in France, in Spain, in Holland, Netherlands as we call it today, and in England. Now, in 1688, in a bloodless coup really, Mary, his daughter, who was a Protestant, with her husband, came over and overthrew James II. But that overthrowing of a constitutional monarch came at a very important constitutional price. And what was the price? In order to get the parliament to support her accession to the throne. That's why bloodless revolution. The monarch had to give away various rights back to parliament. So 1688 is also the year that the famous Bill of Rights was signed in UK. And parliament became the site of political and legislative power. And the king became the notional head. And therefore, we have this notion in British parliamentary law after 1688 of the crown in parliament, the king in parliament, and currently I guess we could call it queen in parliament, where the crown is the head of state, but the powers of government, which were earlier with a single monarch, in an Austinian sense, you studied Austin in first year, the governmental powers very clearly shifted to the parliament. So you would have a prime minister and a minister who would acknowledge the crown as the head of state. And but these ministers would have to have the support of parliament. Okay, and therefore parliamentary support was necessary, and they were responsible technically to the crown, but actually in reality responsible to parliament. So the start of the parliamentary idea of a parliamentary government, a government responsible to parliament, the executive responsible to parliament, is in fact older than the doctrine of separation of powers. Because it's only in 1748 that Montesquieu wrote his famous book, The Spirit of the Laws. And it's only in 1787 and 1789 that US Constitution and the First Republic of France and its sort of draft declaration, etc., incorporated the idea of separation of powers. So if one were to study historically, the fusion of powers principle, which is incorporated in parliamentary democracy. Why do I say fusion of powers is incorporated in a parliamentary democracy? The reason is there is a fusion. The legislature and the executive together are members of the same body. They're not separate. That fusion of powers is historically older than the doctrine of separation of powers. Now, the myth of 1688, I'm spending a little time on it because you will find passing reference to it in the different judgments. And oftentimes, while we are studying Indian constitutional law, some idea of external constitutional law, and I must tell you, two countries that I think one must study in somewhat detail, three countries. One is, of course, the US and UK. And the other country, which is of great interest to us in India, is actually Pakistan. Because there are many learnings for us to be had in the way in which the Pakistan constitution developed, and we should perhaps be grateful that ours didn't develop in that way. So not as a learning, but, there is learning from success, there's learning from mistakes, and if one is wise, one will learn both ways, right? Okay. Now, 1688, therefore, let me just say my last point before I come back to the Indian Constitution. The Crown always, instead of the Crown directly running the executive and the government as it existed before 1688, the Crown would operate through advisors. And all action would be taken in the name of the Crown, but these advisors would be responsible in Parliament. So look at this, the distinction between name and responsibility. Action will be taken in the name of the Crown. In India, action is taken in the name of the President of India. The advisors to the Crown in England, who were actually the ministers, however, took complete responsibility for every action. So it would be the minister and the officer subordinate to the minister who would come to Parliament and reply to questions and be responsible for executive action, not the Crown in whose name all action was taken. So you separate the name in which the action is taken from the person who actually acts and who therefore will be responsible to Parliament. And you see it therefore in two section articles in our Constitution, Article 75 and Article 77. Article 77 tells us that, I go back, please open Article 77 again. Yes, look at 77.1. All executive action shall be expressed to be taken in the name of the President. Okay. And then look at 75. The Prime Minister shall be appointed by the President and other ministers shall be appointed by the President on the advice of the Prime Minister. So, Prime Minister appoints the President. Okay. 1A and 1B, let's just very quickly look at it. I'll come back again because I'll want to look at Delhi as a case study for this. That now after the amendment, you can have only 15% of the total membership who will become members of Parliament. Why is this so? Ruling party cannot make every loyalist as a minister because this is just a drain on the exchequer. And if you want to lure an Ayaram, Gayaram and get defection, the easiest carrot to dangle is to say, "Bhai, minister bana denge, aaja." So, in order, as part and parcel of the 10th schedule and the limitation on how people can defect after they've got elected on the party ticket, one of them is also 1A, which puts a cap on 15%. Please note that whatever I'm saying for the union executive holds true 15% cap for state executive. However, let me just mention it. You can look at it later. But when you look at Article 239A, those union territories which are actually having a legislative assembly, Delhi and Puducherry, the cap is actually only 10%. Just keep it in mind. We'll go into reasons and all later. Okay. And then 1B. Okay. Right. Now let's come to 75.3, which is what I want to focus on right now. The Council of Ministers shall be collectively responsible to the House of People. The Council of Ministers, collective responsibility, and I'm going to go into this. If there is collective responsibility, why is it that an individual minister is prosecuted? The most celebrated question, of course, is of Mr. A. Raja, who was individually prosecuted for the various telecom, auctions, blah, blah, blah. Okay. If it is collective responsibility, can an individual be prosecuted? We'll come to that later, but keep it in mind that these are the kinds of questions we're going to look at. But for now, 75.3 tells us you are collectively responsible, not to the entire parliament, but to the Lok Sabha. You must have the support of the Lok Sabha and you must be accountable back to the Lok Sabha. Now, this division, then action in the name of the president under 77, but the minister who acts on behalf of the president will personally be liable, or the ministry or the cabinet in this loose unconstitutional sense that I'm using the word, will be responsible to the Lok Sabha. So you see a splitting of name in which action is taken and responsibility. Another feature of British parliamentary democracy, 1688, which is the model that we adopted here. And in fact, Dr. Ambedkar made the point that in that earlier debate that I was referring to, whether we should have a parliamentary form or a presidential form, and while he acknowledged that the presidential form has greater stability, he pointed out, I mentioned to you that this has greater responsibility. But he said, but we would still like to use the name of president rather than any other nomenclature for the head of state in India. So we have the name of president coming to us from the American constitutional law, but the prime minister and the accountability contained in Article 75(3). Now, it's reflected also in Article 300 that while 77 says that action is taken in the name of the president, when you want to sue the government for any action taken as part of its executive action, the proceedings will take the name of Union of India. And this is further buttressed by 361 and the immunity point that we've discussed in the earlier class. I'm not going over it. Now let me come to Article 74. Article 74 says there shall be a council of ministers with the prime minister at the head. How this is the composition? The appointment question is addressed in 75, that the president shall appoint the prime minister and the various ministers on the advice of the prime minister. So now look at 74. It just boldly tells you there shall be a council of ministers with the prime minister at the head. Yesterday's class, I pointed out to you that the normal English principle of primus inter partes would make for a more flatter or a more democratic cabinet. But because 74 uses the expression head, they are not equal. Very clearly, there is a hierarchy within that council of ministers, the head and the rest of the members, to aid and advise. Their role is to aid and advise the president. And look at it, his functions. Okay. It doesn't say only in his executive functions. I want to highlight this point to you because under Article 53, the president exercises the executive functions of the union. But when you come to Article 74, it merely says his functions. And we know that the president exercises more than merely the executive functions. The executive functions, what are those executive functions? Ram Javaya Kapoor, still the classic on the subject, the implementation of law, formulation of policy, initiation of legislation, maintenance of law and order, foreign relations, etc. It's inclusive. So at the very minimum, the executive function is the formulation of policy, implementation of that policy, initiation of legislation, implementation of the laws, entering into treaties, maintaining diplomatic relations, maintenance of law and order is at the very minimum of the executive functions. But the president also discharges functions of other natures. Okay? Article 72, which I'll come to, some commentators call it judicial powers, but I actually disagree. It's actually in many Supreme Court judgments, the power of pardon is actually not a judicial function. And I'll come to why I hold that it's not a judicial function. It's part of an executive function. He appoints the Prime Minister under Article 75. He appoints the UPSC. He appoints the CAG. Appoints the appoints the governor, of course, and many other kinds of powers that the president has. Now, it says here that his functions aid and advise the president in his functions and to act in accordance with his advice. Now, very quickly, since I am there, let's just finish off the proviso on 74.2. Okay, because we should just know this, that if you look at the 42nd Amendment, then provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. Now, obviously, if the President is going to return a bill which has been passed by both houses of parliament, or the president is asked to sign the file about appointment of governor, or if the president is asked to sign, a ratification of a treaty. Treaty is also ratified in the name of the President of India. He feels that he does not want to do so. He can send it back to the 44th. I stand correct. Yes, 44th. My mistake. Did I say 42nd?
Yes, ma'am.
Yeah, sorry about that. Now, where was I? Yeah. So you can send it back to the Council of Ministers for reconsideration only once. But second time around, if the Council of Ministers says yes, you will have to oblige. In fact, this thing about sending it back once, that obviously you're sending it back because you're not following the Indian advice. So it stands to reason that the proviso is acknowledging there is that one place where the president acts on his own or on her own without the aid and advice because he has chosen to send the file back. What we are interested in knowing, other than the one instance that is expressly acknowledged by the proviso to 74.1, are there other instances where the president can take his own call outside of the aid and advice? Okay, we'll come to that later in today's class. But come now to 74 clause 2, which is actually a question of admissibility. Okay, it is relevant but not admissible. That wonderful phrase from Evidence Act. The question whether any, and if so, what advice was tendered by ministers to the president shall not be inquired into by any court. What 74 clause 2 is acknowledging is that no doubt it is relevant, but it is not admissible. Right? Oh, I'm sorry. Spelling is bad. It is relevant, but it is not admissible. Yeah. You studied Evidence Act, have you?
Yes, ma'am.
Right. What's the difference between relevancy and admissibility?
Ma'am,
no, answer my more specific question. Why is this relevant and why do I say it's not admissible? What does it mean?
ma'am, if we see Evidence Act, in Evidence Act, section 5 to 55, it speaks about relevant facts.
Yeah.
Admissibility depends upon court. Will the court admit this fact or not?
No, it doesn't depend on the court. Are there no rules in the Evidence Act relating to admissibility? Is it the whim and caprice of the judge? Is the Evidence Act entirely silent on the questions of admissibility? You talked about relevancy 5 to 55, I accept. Is relevancy a subject matter of law and is admissibility the complete discretion of the judge?
No, ma'am, it's also provided in the law. Admissible, like privilege commission conversations which may be relevant but are not admissible. Like
so what are the broad principles of admissibility?
Ma'am, every relevant facts are not admissible.
Oh, yes, why are they not admissible? On what basis do we exclude a relevant fact?
Ma'am, to maintain confidentiality and privileged communication.
Okay, so that's what I think Abhishek also said. That we're talking about privilege, but are there any other grounds of inadmissibility? So one ground of inadmissibility is privilege. Yes, somebody who wants to say, please do.
There's exclusion by fiduciary relations.
Exclusion by fiduciary relations.
Ma'am, there's also exclusion by estoppel. Section 115 to 117, exclusion by estoppel.
Yeah, okay. Admission by estoppel, okay. What is the one about fiduciary?
Communication within fiduciary relations is not admissible, ma'am.
Section?
Section, I don't exactly remember.
No, that which is relevant to prove the fact in issue, section 4, you have all the rules of relevancy. Now, what advice was given certainly is a relevant fact, but Article 74 subclause 2 makes it inadmissible. Now, this has come up repeatedly. It has come up once or twice actually, whether the advice given, should the military have been called in to control riots in a state? What was the advice that the government gave to the minister, the Prime Minister? Fact in issue, relevant fact made inadmissible by Article 74, subclause 2. Since we are on this point, I'm not giving you the answer to it, but you can separately find out, and there's lots and lots of issues here on it. Is this subject to RTI or not? Whether this would be under RTI or not is the other fact, which is slightly different from the question of admissibility. Now, 74 clause 2 is therefore dealing with the question of evidence. Has there been a case in the Supreme Court which has examined the evidentiary value and the principle underlying Article 74 clause 2? And the answer is yes. The 9-judge bench decision in SR Bommai case. And the question was, while President's rule was being imposed in Karnataka and when it was being imposed in Madhya Pradesh and Rajasthan, following the Shilanyas program at that time, I'm talking not about this Shilanyas, I'm talking about the 1992 Shilanyas after the Rath Yatra. And the state governments for law and order reasons were dismissed and President's rule was imposed. The question before the Supreme Court was, tell us what was the advice that the Union government gave the President prior to the President signing the file on Article 356. And SR Bommai ruled that because of Article 74 subclause 2, the advice given to the President cannot be admitted. But, and this continues to be good law, it is the 9-judge bench decision. For the first time, what did the Supreme Court do? It made a distinction between the aid and advice which may have been written on the file and said that this aid and advice is made inadmissible by Article 74 clause 2. But the material upon which this advice was based, what is that material? The report from the governor, maybe the report from the intelligence IP, maybe other documents of what political parties were saying. All these documents, on the basis of which a mind was made up by the government to advise the President that, Hanji, please impose President's rule under 356, that what 74 clause 2 is to merely bar the advice but not the material upon which that advice was based. And this was a very elegant judgment that narrowly construed 74.2 in order to expand the scope of judicial review. You can see the profound political interpretation, significance and consequences of SR Bommai's so holding. And therefore, after SR Bommai, and you come to the next judgment, there have been lots and lots of judgments, but after SR Bommai in our case material, we look at Rameshwar Prasad versus state versus Union of India, which is dealing with the imposition of President's rule in.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।